letter arising out of the notice issued by Anchal Adhikari
जी
without directing the petitioners and others to vacate the premises which they have been occupied for the last 60 years, and after
Public Land
constructing
Encroachment
house,
Act.
they are living in the house. Milord, they sought this LPA is directed, Milord, against the order of Honorable Singhal Judge. Honorable Singhal Judge, Milord, did not refuse, did not dismiss the claim of the petitioner. Rather, they did not allow the petition of the petitioner on technical grounds. And observation has been made by the Honorable Singhal Judge that whatever has been observed in the order, it will not decide negatively the case of the petitioner. Petitioners may seek the remedy before the appropriate forum.
The judge was the single judge was very kind on you.
Last paragraph of the Honorable Single Judge Miller. It is, however, has my Lord got it. It is page 5 of the order, impugned order passed by Honorable Single Judge. Your observation is like this. Last paragraph. It is, however, made clear that any observation made in the instant order may not be taken to be an expression of opinion on the rival claim. The petitioners would be at liberty to avail their remedy under the Bihar Public Land Encroachment Act or any other forum in accordance with law for their claim in respect of the lands in question. So my humble submission for my Lord kind consideration is the Honorable Single Judge had not negated the case of the petitioner. Rather, they have directed me, and because of technical ground, they could the claim of the petitioner was not allowed. Short fact is like this, my lord. In 1958, there was great flood and erosion in the river Ganges, and because of that erosion and flood, house of several villagers were completely washed away with all its belongings, and land was also washed away. And in this way, the petitioners and some other villagers had nothing with them to maintain themselves, and there was no place for residential purpose. For seeing this situation, my lord, the state of Bihar official was pleased to allow the petitioners and other 40 to 45 displaced, flood displaced persons, 1 decimal, half decimal, 2 decimals, 3 decimals, in this way to all the displaced persons, 40 to 45 in number, and altogether only 92 decimal and 8 points have been allotted to them. Petitioners never encroached a single inch of land than the land allotted. They have been still living upon this land. And one Prabhakar Kumar, because of personal jealousy, my lord, filed petition before Lok Shikayat Nivaran Pradhanikari that encroachment should be removed from plot number 790. This is the plot in question, out of which, my lord, 92 decimals land were allotted to all flood displaced persons. Thereafter, my lord, the Lok Shikayat Nivaran Pradhanikari found none was mentioned as encroacher in the petition. Still, my lord, Lok Shikayat Nivaran Pradhanikari, being a very sensible and prompt officer, issued notice to Anchaladhikari Gogri to make a spot inquiry and report. Anchaladhikari made, my lord, the spot inquiry through circular inspector in charge and Halka Karmachari, and came to the conclusion that petitioners are not encroachers, they are flood displaced persons, and recommended the case of the petitioner to Lok Shikayat Nivaran Pradhikari that they are suitable persons and land should be settled to them. Thereafter, my lord, the matter continued for 4 to 5 days before Lok Shikayat Nivaran Pradhikari. Prabhakar Kumar, who filed petition to remove the encroachment, did not appear even on single day. Not even a sheet of paper was produced against the petitioner that they are encroached. Thereafter, my lord, Lok Shikayat Nivaran Pradhikari dismissed the petition of Lok Shikayat Prabhakar Kumar filed on 1/8/2018. Now, my lord, what mistake was committed? Now, my lord will come to section 3 of Bihar Public Land Encroachment Act, my lord. Section 3 says, my lord, if there is any petition before the collector, by collector, my lord, I mean the collector under the act, before the collector, or any information before the collector that government land has been encroached by particular purpose, by particular person. In that case, collector will issue notice to the person concerned, giving him at least 2 weeks time to show his defense. In this case, my lord, opportunity was not given to me, and to explain my position. On this point, my lord, there are several rulings of our own High Court, my lord, that the person can't be unilateral view, can't be taken by the state.
That's
when
right.
I am living on the land, my lord, for the last
That's
60
right.
years.
That's right.
After constructing
So therefore,
no opportunity
that's
was given to me.
so therefore the
There
court.
are numerous decisions, if my lord.
नहीं नहीं उतना किताब की जरूरत
Then I am to thank my lord.
उसकी जरूरत नहीं है कि कोर्ट ने आपके पिटिशन को आपकी ग्राउंड्स को नेगेटिव नहीं किया है, विच यू हैव अंडरस्टूड इन नो अनसर्टेन टर्म्स. द कोर्ट ओनली सेज दैट यू हैव एन ऑप्शन टू चैलेंज so far as adverse possession is concerned, that is to be established before an appropriate court of civil jurisdiction, and you shall be noticed. Now the first report of the circle officer which says that parcha could be issued in your favor, that means nothing, because there was another inquiry later which says that you are one of the encroachers. Nonetheless, you shall not be disturbed, dehors the rules under the Bihar Public Encroachment Act 1956. That's for sure.
My humble submission.
Now beyond that, the court cannot travel.
If the order is patently illegal, my lord, in that case,
We are clarifying the order. We are not.
does not stand in the way.
That's all right.
My lord, I have numerous decisions on this point also, my lord.
The order, just a minute. Let us see. आपकी बात ही, वो ठीक है, वो पता है मुझे लॉ. आप मिस्टर नारायण सिंह, you show us the notice which you had challenged before the learned single judge. Notice dated 17/3/2020. Writ petition है आपके पास?
हाँ, notice is only, my lord, to vacate the premises by 3/4 or without giving me an opportunity of hearing. Notice is, my lord, impugned order after page 21. Notice, my lord, I am reading. नोटिस बजरिए नोटिस द्वारा सूचित किया जाता है कि निम्न वर्णित जमीन पर जो पंचायत सरकार भवन बनने हेतु प्रस्तावित है, उस जमीन पर आप लोगों के द्वारा अतिक्रमण कर मकान बना लिया है. जमीन गैर मंजूर आम किस्म की है. उक्त जमीन से संबंधित कोई कागजात हो तो आप लोग स्वयं 3/4 को कागजात के साथ उपस्थित हों तथा अतिक्रमित स्थल को उपरोक्त तिथि के अंदर खाली कर दें. पहले तो हमको कहता है खाली कर दें, और इट इज मिलर फ्रॉड upon the
समझ
court
गए आपकी
कि
पिटीशन
पंचायत सरकार गवर्नमेंट के लिए जो जमीन
ठीक
है
है।
बिल्कुल खाली पड़ा हुआ है। My lord will kindly see.
All right,
My
Mr.
lord
Naraj,
will
we are
kindly see annexure C.
आपकी जो फियर है उसको एलिविएट कर देते हैं, इस ऑर्डर को सेट साइड नहीं करते हैं। आप उनके वो असिस्ट कर रहे हैं, आप इनके बाएं तरफ आइए, टेल हिम दैट नहीं कोई हर्ज नहीं, मैं बता रहा हूँ, मैं कह रहा हूँ, अरे पहले तो मेरी बात सुनोगे ना, मेरी पहले बात तो सुनेंगे तब ना उनको बताएंगे। मैं कह रहा हूं कि मैं सिंगल जज के ऑर्डर को पार्शियली मॉडिफाई कर दे रहा हूं, और इनकी जो फियर्स है कि इनको वैकेट कराने कहेगा, उसको कहेंगे कि नॉट विदाउट फॉलोइंग द प्रोसीजर अंडर बिहार पब्लिक लैंड एनक्रोचमेंट एक्ट, वो करेंगे, इनका जवाब देंगे और तब खाली करेंगे। ये जो राइट ऑफ एडवर्स पोजेशन और ये सब बात कर रहे हैं, ये जो कोर्ट ने कहा है वो मैं मान रहा हूं, लेकिन इनको इनकी फियर को मैं एलिविएट कर देता हूं बाय मॉडिफाइंग दी ऑर्डर। ये बताओ।
My lord will kindly see और notice is absolutely.
उस नोटिस को मैं हटा दे रहा हूं, वो नोटिस गलत है,
इस नोटिस को हटा दिया जाएगा,
फ्रेश नोटिस आपको करवा रहे हैं।
फ्रेश नोटिस करवाया जाएगा।
मेरा local authority is biased under the influence
वो तो
of
आप देखिए, आपने आप
मुखिया and प्रखंड. My lord will kindly see this. His own annexure bill filed by the state at page. My lord will kindly.
Mr. Anand Ojha, can you please come in front? एक मिनट मिस्टर ओझा, एक मिनट, मिस्टर नारायण सिंह, आप एक मिनट बैठिए। आई एम सो हैप्पी टू सी दैट सच एन ओल्ड टाइमर इज एड्रेसिंग द कोर्ट। बैठिए, हम बता रहे हैं, he will tell you. Mr. Ojha, I'm not asking the state because he is an adversary party. Yes. Now you please hear out the court. Now they claim to be in possession of the land since 60 years. They say that after their lands were taken away from the river because of the river course, they are there on that property and they have constructed their lands. Now one of the circle officers at one point of time had said that the lands belong to them. Even if it doesn't belong to them, they are entitled for parcha. This was done sometimes in the year 2018, but later the matter was inquired in 2020 and it was found that they are encroachers. But instead of proceeding under the Bihar Public Land Encroachment Act 1956, the circle officer issues a notice to them to vacate without hearing them, without anything. The single judge found that their claim of adverse possession cannot be decided in a writ petition, right? We don't have any objection to it. The court also said that the notice, on the notice they were required to present their cause, and any order passed on such reply was amenable to further scrutiny by the superior authority. The single judge perhaps did not consider that the notice itself was bad in the eyes of law, because it was a vacation notice to vacate by the circle officer. So what we do is that we partially modify the order passed by the single judge and we direct for proper proceeding against them.
But that proceeding has to be under the Land Encroachment Act only.
Public Land Encroachment Act.
Because under that law only, the position of the parties is like plaintiff and defendant.
That's right. So this is what we are going to do. So make him understand that. इन नोटिस को सेट असाइड कर देना। नहीं सब अभी कहाँ एनक्रोचमेंट हटाने का बात है, लाइटिंग करते रहेंगे।
My lord, he has understood. He has understood, my lord.
So we are not sort of diluting that part of the order which says that with respect to right of adverse possession, they are required to go before the civil court.
नोटिस में
तो
रिक्वेस्ट
वो सिविल कोर्ट जाते रहेंगे, देखते रहेंगे, यहाँ अपना जो जवाब देंगे वो
अभी
offer.
अभी तो इनको जो एविक्शन से प्रोटेक्शन
अभी
मिलेगा.
eviction से प्रोटेक्शन मिल रहा है. मैं इसको partially modify करता हूँ because many parts of the order passed by the London single judge is correct. We can't interfere with that.
Very well.
But otherwise we provide a way out for him.
Lord, so the only window to the authorities is that if they intend to do anything with
Under
respect
this, under this, when they file an explanation and when they say that they hold it by way of adverse possession, that shall be rejected by them. They have the option to go before the civil court, number one. Number two, before the superior authority against this.
ठीक.
I think that would be the most fair. नोटिस को हम कोश कर दे रहे हैं, ठीक है ना. चलिए, थैंक यू मिस्टर ओझा. Heard Mr. Narayan Singh, learned senior advocate for the appellants, and Mr. Shailen Dwivedi for the state. Claiming adverse possession over the land in question, as the writ petitioners have been residing on that land since 1962, an attempt was made to forestall the process of their eviction from the said land. The writ petitioners slash respondents, the writ petitioners slash the appellant slash writ petitioners had come to this court for quashing of the notice dated 17/3/2020 issued by the circle officer Gogri in encroachment case number 13 of 2019-20. Mr. Singh, learned senior advocate, has drawn the attention of this court to the contents of the notice, which in fact is a notice to the writ petitioners to evict the land without hearing their response. However, we find that an encroachment case has already been initiated against the writ petitioners, appellant slash writ petitioners, by the encroachment case number 13 of 2019-20. First off, in the notices which were challenged before the learned single judge, there is no averment that there is an emergent necessity for direction of the eviction of the writ petitioners from the land or the structure erected thereupon in which they have been residing for the last several years. The learned single judge rejected the plea of adverse possession of the writ petitioners on the ground that it would be required to be established before a court of competent jurisdiction. One of the pleas taken by the writ petitioners before the learned single judge was that in the year 2018, a circle officer, after finding that the writ petitioners were landless laborers, suggested that they be given parcha under the Bihar Homestead Act, under the Bihar Homestead, under the Act, under the Act. However, when the matter was inquired into, a report was submitted by Revenue Karmachari on 6/10/2020, in which it was found that the writ petitioners slash appellants were encroachers on the government land. The learned single judge has, however, not negatived the contention of the appellants slash writ petitioners, but has directed them to appear before the authority, and in case they are aggrieved by any decision, they could take recourse to the relief to which they are entitled under law. However, on going through the records, we find that the notice which was challenged before the learned single judge was bad in the eyes of law, as no 15 days, no clear 15 days was, no clear 2 weeks was given to them to represent their cause. First off, in fact, the notice was an intimation to the landholders slash writ petitioners slash appellants to vacate the land in question. First off, we are of the view that though the learned single judge was absolutely justified in holding that the issue of adverse possession could be established, was required to be established before a competent court of civil jurisdiction, but we partially modify the order of the learned single judge in which he has chosen, by which he has chosen not to interfere with such notice issued to the appellants. First off, the notices issued to the appellants on 17/3/2020 is hereby quashed. First up, the authorities shall furnish fresh notice to the appellants and shall give them 15 days time to represent their cause. Thereafter, a final decision shall be taken. First up, the authorities, before passing the order, before passing any order holding the appellants to be encroachers, would give support, would give reasons in support of the same. First off, in the event of the appellants slash writ petitioners being dissatisfied with the decision of the authority, comma, they could take recourse to the provisions contained under the Bihar Public Land Encroachment Act 1956. With the aforesaid modification, the appeal stands allowed. First off, such notice shall be issued to the such exercise shall be undertaken by the authorities within a period of 60 days from the date of receipt of the production of a copy of this order.